Is that the GST, HST tax return? Okay, just don't. Is that something you get with your income tax?
Yeah, when you get your papers for the.
Yeah, I don't know.
Oh, so you guys start.
Oh. Provided documents to mail and notify lease agencies, okay. Yeah, I get it. Well, that's what I got, when Mom died, they provided me with that. I have a whole thing at home that tells you, well, actually, it doesn't tell you, it has a list of all the things. That's this, that, so that he doesn't have to go to the week or so. So it's all ready for.
So obviously this is gonna be a very intimate crowd here.
Apparently,
So,
yeah.
Just so we do, just so you guys are aware, it is being recorded. So you guys are being recorded, that little camera there's just recording.
Okay.
So just so you guys are aware.
So don't laugh out, don't,
Ask all
obscene
the
words.
appropriate questions that you
Then
want.
watch your language and, just
No,
kidding.
we prefer,
Just
we
kidding.
prefer you to be yourself. You just give her. We'll be starting just soon here.
Okay.
Neil? Yeah, this one, so.
In the past, the CBD death benefit was 2,000.
Oh, okay.
I wonder if it's changed.
Okay. So this is all stuff I didn't know that.
Just so you know. Okay, yeah, great.
I mean, my sister-in-law would have tons of knowledge. She just, yeah, all this stuff, right? So she would know. Yeah. Yeah, it says all this information on this one or two sheets there, so I haven't filled it out yet, it's taken me, I haven't done it yet, but I should get it out and do that, so that he has all that information.
Oh, when I see things about the marriage certificate, I'm like,
Oh,
I had one at one point in time, but I think it's all over now.
Yeah.
It's all my,
They work stuff, yeah. Well, that makes sense. Yeah, see, ours would be non-existent because we're just contractor 18 years.
back in the day, they had those kind of records, it certainly would be computerized. My Department of Biostatistics in every province.
I would think so. I would think at some point they digitize and stuff, right?
Very nice, I'm just gonna start her
It
off.
wasn't the Stone Age, but it was a
Well, pretty. Oh, well, Stone Age would be my mom and dad's.
All right, guys. Perfect. So, my name is Kevin Smith. I'm the funeral director and ball brand owner of Kettle Valley Memorial. So, first of all, thanks for making it out today, coming and hanging out with us to learn about planning your funeral and also what goes into estate planning, things like wills, powers of attorney, things like that. I guess my first question to you guys is, does anybody here have a pre-arrangement already? No? Okay. Sometimes people come in because they just want, they do have a pre-arrangement, they want to get some more information, because maybe they did theirs a long time ago, so. Okay, no, that's perfect. So, I guess, if anybody has any questions as we're moving through, just raise your hand and, we'll stop and answer any questions you might have. If you're hungry, thirsty or anything, as you guys know, there's some snacks back there, so feel free to help yourself. But what I'm here to talk to you today about is pre-arrangements. So what is a pre-arrangement? Pre-arrangement is getting your final wishes written down, put into a file, given to or at a funeral home, given to your executor so that your final wishes are taken care of at the time you're passing, okay? Obviously there's two ways right now in the province of British Columbia to for disposition, one being cremation, one being burial. Okay, so when we do pre-arrangements, we want to know for sure. Okay, hey, what do we want to do? burial or cremation. A lot of times people come in and they say, you know what, we don't know what mom or dad wanted, right? So they gotta talk with the family, figure it out. Pre-arrangement is gonna, number one, set that out for the family as to what they're looking for, okay? Two, we're gonna relieve a lot of the burden by being able to present that to families, or to our families, saying, hey, you know, we wanna be cremated, we wanna have just what we call as a simple cremation, no service, or a full traditional funeral where we go to the church, or we have a celebration of life at a hall, at the funeral home, whatever works. We want to have those down so that there's no disagreement between family members or anything like that. Three, we want to lock in those prices today. When we do pre-arrangements, we pay for them. We lock in the prices today so that in 20, 30 years when we pass away, it's already locked in prices. Our family isn't gonna have to pay the over and above charge. They won't pay today's prices, they'll pay today's prices 20 years from now, right? So when funeral costs keep going up, they're locked in at this. And we'll go a little bit more into that because people think, oh, hey, you know, there might be some things that aren't what we call it, or being able to prepay, things that aren't guaranteed costs, okay? We'll also touch on what the difference is between a trusted pre-arrangement and an insurance pre-arrangement, because there's two types, okay? And then also, obviously just having the peace of mind. So number four, I think, is having just the peace of mind of knowing, hey, everything's taken care of for our kids. We know they know exactly what we want. They have the piece of paper, and you know, we can go on living, not worrying about what happens to us if we pass away. So, does anybody have any questions just from that? Yes.
What if, so I'm 60, so if I do this, what if 30 years from now, you've moved on because you've decided to move to Europe, blah, 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 and Hill Valley no longer exists?
Absolutely. So, that's a little bit of an in-depth question. I'll just start with that. So, with this funeral home, we use insurance pre-arrangement. So, we use a company called TrueStage. So, you come in, you meet with me, we have your pre-arrangement all done up. The money that you pay goes to a company called TrueStage. That company holds the money in their big account until you're passing. The only way that money can be accessed is one, you cancel, decide, hey, I'm not going to die anymore, I want my money back, you cancel it, or you pass away, we have to submit your death certificate to them with some other paperwork that allows them to pay us. If we are not in business, or we've sold or shut down or whatever, that money stays with TrueStage. So there's when a funeral home closes or is bought out by another funeral home or whatever, certain things have to happen. So each family member that has a pre-arrangement, or every person that has a pre-arrangement, has to be notified of, if it's a big change, if that funeral home, they have to be notified that the new ownership or this funeral home's closed down. Now you're more than welcome to go find another funeral home to switch your pre-arrangement to, or the new funeral home taking over your pre-arrangement. They'll let you know. We have it. It's all guaranteed. So
Okay.
everything like that.
Okay.
So we'll go a little bit deeper into the trust and assurance. So most funeral homes have what they call as a trust account. Okay. That trust account is set up by the funeral home at a financial institution here in British Columbia, and that's where your money would go into. When you pay, it's some paperwork's filled out, that money's sent to, whether it be Scotiabank, TD Bank, TD doesn't do it anymore, but any other bank is where those will be held. It can only be accessed, like I said, two ways. One, you cancel. Two, it is you have to pass away. Now, trusted pre-arrangements are under a completely different set of laws than insurance. The thing about trusted pre-arrangement, I tell everybody this. One, when you cancel your pre-arrangement with the funeral home for when it's held in trust, the funeral home can hold all the interest and up to 20% of the premium. So, and a lot of people, when they find that out, that's not good news, right? They think, oh, I want all my money back. We don't do that. We make sure families get all their money back. The other thing too is with trusted, a little bit harder to transfer around. Like I said, if you live here in Penticton and you decide you're gonna move to Tofino because you like to serve, you have to go to a funeral home there, find them, say, hey, listen, I have a pre-arrangement with Kettle Valley and Penticton. We're moving, can we get a transfer? They're most likely gonna make you cancel, keep that money, and then give you the remainder. Then you gotta go to another funeral home and basically start over again.
Okay.
Or have it transferred over, but even still then you can lose money. With insurance pre-arrangements through TrueStage, it's done very well. I think that the company, it's a big company, but the way that they handle their business is second to none. So, insurance pre-arrangements, when you have one of those, it's not one of the things where it's like you pay monthly and then after 3, 5, 10 years you have to renew and pay again. Once you've paid for that, you own it, okay? Your money stays with that company, you own that policy. They send you the paperwork and everything's paid up and done. The nice thing about TrueStage is mostly every funeral home in Canada, I would guess, has an account with TrueStage. So if you have a pre-arrangement here with us, and like I said, you decide to move to Tofino, you would go to the funeral home there and you would say to them, hey, listen, I have a pre-arrangement with Kettle Valley Memorial, here's the paperwork, our money's with TrueStage. They'd look at it, they'd go, great, they print off a form that's called an assignment of benefits form. You sign that, they send that to TrueStage, they take my funeral home's name off of your file, off of like your money, and put the new one on. The funeral home phones us here, hey Kev, families switch their pre-arrangements over to us, can you send us the files? We scan them, we email them over to the other funeral home. You don't pay anything, there's no cancellations, it's just a very smooth transfer over to another funeral home. Can happen as far as going, I've had it where people have passed away down in the States, so going over the border and having their pre-arrangements, it's still honored down there in Palm Springs. Glenn, where do you vacation?
Where do you vacation? Well, let's see. Where do you vacation? They don't vacation right now.
Yeah, names are just jumping in here.
No, that's okay.
Yeah, that's okay.
Yeah.
Palm Springs works well.
Palm Springs, I've done one down there, so where it's worked across borders. Okay, so pre-arrangements today. Big thing that we want to do is lock in the cost, so that we're not having to pay for those extra costs at the time of our passing, and our kids or whoever our next of kin or executor isn't having to pay for those extra costs as well. Now, a pre-arrangement, there's two parts to a pre-arrangement. One is what we call as our guaranteed funeral service costs. So that's going to be things that the funeral home controls, the prices that the funeral home controls. So our professional fees and staff services. If you guys actually open up your planners, you'll see our price list in there, just to give you a little bit of an idea. Perfect. So you'll see it in there. You'll have, those are all the costs that the funeral home controls. So those are the costs that we're going to lock in. You'll see on there, probably the easiest reference would be if you guys flip to the second page, there's a one called simple cremation. So simple cremation. So basically you'll see on there it says like professional fees and staff services, $3.99, right? So that is locked in. If in 2 years we bring that price up to $5.99, it doesn't matter. You've paid that, you will not pay the over and above. Okay, so that's what we call our locked in guaranteed prices. Okay? Perfect. As we go through there, you'll see things in there like transfer, documentation and registration, facilities and equipment, But down at, over on the other side too, you'll see a spot that says, talks about caskets. You see that on the other side? Let me just, let me grab it.
I'm at the celebration website.
Actually, if you
Oh,
just.
yeah, it says it right here.
Okay, so
Cremation.
additional considerations.
Oh, gotcha, right
There we go,
It's right.
perfect, no, that's okay.
It's
So,
right here, look.
yeah, so it will say, it says additional considerations, so those are also things that can be guaranteed by the funeral home or might not be guaranteed by the funeral home, okay? So things like casket, cremation container, urn, memorial cards, things like that are what we call guaranteed still. So what you pay today is what's locked in. You will not pay more in the future. You'll see on there, there's a part that says disbursements or non-guaranteed. You guys see that there? So those are things that you can, when we're doing a pre-arrangement, you can prepay things like obituaries, cemetery, flowers, honorariums. You can prepay that. The only thing is because we don't control those costs. If you, like today, to buy a plot out at the Penticton Lakeview Cemetery, a casket plot is going to be about $4,500. If you pay that today and we put it into your pre-arrangement, and in 20 years it's worth $6,000, just say, that $4,500 will go towards it. The family will still be responsible for that over and above of the other $2,000. Okay. So does that make sense?
Yeah.
Because you don't control that.
We don't control that
Yeah.
price, exactly. And a lot of people, that's the big thing, a lot of people think, oh, we've heard it as funeral professionals. They come in, they say, oh, we're all taken care of, it's been prepaid. And then we look into it and it's like, well, yes it has, you've put money towards it, but it's not guaranteed, because it's not a price that we control, okay? Little tip on the side, in Penticton, the city of Penticton runs the cemetery. They own it, they're the ones that handle it. You cannot pre-purchase a grave plot in the city of Penticton, and I'm just talking a single grave plot today. You can't go down there and say, hey, we want to buy this one. You can reserve it, but you can't buy it. You can with things like the family plots and the columbarium and niches. Those are the places in the wall, the urns and stuff. But you can't, when it comes to just going in and buying your plot today, you can't do that. They'll allow you to reserve it with the money you pay, but pay towards that doesn't go towards the purchase price down the road. Okay?
So is that only in Penticton, or are there some communities are different, or?
Yes, some communities have different bylaws and they allow, like where I'm from in Lethbridge, you can go down to the Mountain View Cemetery, you can buy your plot in the ground. You can go there, say that one's mine, pay for it. At the time of your passing, you have to obviously pay for them to dig the hole and stuff, but you purchased that plot, okay? So it all depends on where you're at. Well, you know, each municipality is different for the most part. Places like Naramata Cemetery, you can go and you can pre-purchase your plot there. Yeah.
They have a
Okay.
cemetery?
They do, it's gorgeous. Yeah, it's there's no lake view or anything like that, but it's just like such a nice little wooded in area. It's really awesome. Yeah. Yeah. So things we need to also watch for when we're doing our pre-arrangements, and we want to be clear about when we're sitting with the funeral director talking about our wishes. You don't know what you don't know, right? So one of the big things is you want to ask the question as, if I pass away at 2 o'clock in the morning, will I be charged an overtime fee? Even though you have it prearranged. Oh, well, mom passed away at 2 a.m. We had to send somebody out, so that's going to be $300. You want to ask those types of questions to make sure that, you know, we're all under the impression that we've prepaid our funeral and everything's taken care of. Well, guess what? Sometimes there's things that happen. And ask, funeral homes will charge for removing a pacemaker. Some will charge for dressing and casketing, for viewing, for other things that would be added on top. Your pre-arrangement would still cover everything. It's just the other stuff that you might want to do that they'll charge for. So you want to be clear when you're doing your pre-arrangement. Ask questions. Okay, you know, what happens with the metal in the body? Not that anything happens, but it's just one of the big questions that comes up, right? You want to make sure that it's very clear what the funeral home is selling you in that pre-arrangement. Because there's nothing more frustrating than going into planning your loved one's funeral already, you know, stressed out about the situation. You just lost a loved one, and finding out, hey, you're gonna owe us another $300, and then another, oh, you want to do a viewing? Yeah, it's gonna be another $500, and this. You just want to make sure that you're covered. Okay, so don't be scared. Ask the questions. Any questions yet? Now that we're at that part.
What do you charge for those things?
Nothing. We don't charge for viewings and things like that. We don't charge for embalming or anything like that as well. We find that people will make like grief decisions based on the price of something, right? So we've eliminated like viewings, things like that. I mean, if you wanted to do a viewing on a Sunday afternoon, then yeah, there might be a charge to come in because we got to bring people in. But Monday to Friday, we do viewings, dressing, embalmings, all that, no charge. Just so you guys are aware, on the back of that price list as well, there is other things that you do have to be aware of as well. So out of town transfers, that's a big one as well, okay? You could have a pre-arrangement. If you pass away in Kelowna or Vancouver, most likely there is going to be another charge to go to those places and to bring you back here. So like I said, it's all about making sure you ask the right questions. And I know it's tough, you kind of want to go in, get it done. Nobody wants to sit there and talk about their death or a loved one's passing longer than they need to, but it's one of those big decisions and a costly decision where you're going to want to have people, you're going to want to have all the right information. You're going to want to have that person you're sitting across the table from giving you the right information of what you're looking for, okay? Okay. So, pre-arrangements, and I'm not just saying this as a funeral director here, but pre-arrangements are definitely a really good way to go about taking care of your final affairs. It makes it so that, one, like I said, we've removed the burden from our family, we've locked in the prices, we've made it so that nobody has to question, guess, well, what does mom, what does dad want, what should we do? And the big one, we lock in those prices today. We know that in the event we pass away, or when that time comes, everything's taken care of, and we can just live the rest of our lives knowing that everybody else is going to be taken care of in that situation. So that's my brief part in this thing here. Does anybody have any questions at this point? Perfect. Neil is going to talk to you guys about way more exciting things, being wills and estates. So he's going to dive right in. Does everybody here have a will? Good. Well, he's going to tell you how to make it better. So perfect.
Heather,
Hi.
you all nodded, so you've already got wills and there's nothing for me to tell you? Nothing at all? Well, I'm going to tell you a few things. I'm sure you've already covered this, but the whole idea about wills is just about having certainty. That someday when you die, things will go the way you want them to. And so I made up a couple of stories. These are things that actually happen to clients. And if you've already got wills, then you can smile knowing that this isn't going to happen to you. The first one was Uncle Bob owned a big company, and I worked with him for years and years. All along, Bob was telling me that someday when he dies, the whole company will be mine. He never got around to putting that in writing. He never made a will. Someday, or eventually, when he died, everything went to his spouse and his children, and I didn't get the company. Stand back. All right, too close to you.
Oh, no. Keep going.
Keep going.
Keep going. Good.
All right. I hope you can still see me. So the whole idea that if Uncle Bob had made a will, then I would have got the company the way that we expected. Without the will, I didn't get the company, I'm disappointed, and that's the end of the story. There's not a whole lot more that we can do. So then there's Alice and Jim. They were careful, they made wills, they did it themselves even, they sat at home, they thought through what they wanted to do, they wrote down their wills, they did it properly. And now they came together later in life, they had their own children, they had their own assets, they got married, and they agreed that Alice said what's mine is mine, Jim said what's mine is mine, so their wills left everything they own to their own kids. Sounds like a great plan. They forgot that when they bought their house, they own it together, they registered it as joint tenants, which is really common for spouses. Most of the time when spouses buy property, we register as joint tenants. And the idea with that is that when one joint owner dies, their name comes off the title, and the other person owns the entire home. And it's got nothing to do with the wills. So later on, Jim died. And he had a will that said, everything I own goes to my kids. And the house happened to be their biggest asset. The house was not part of his estate. The house went to Alice, not to his kids. And in this case, Alice was careful and changed her will. But if she didn't, then there was really nothing for Jim's kids to do. The whole home was Alice's, and she could do what she wanted with it from then on. And so that's just an example where Jim and Alice, they were careful, they made their wills, they did it right, but they didn't go all the way to think about how their assets flow when they die. So sometimes doing the right things, but not going all the way, can still be a problem. And then there's an example of Steve and Stephanie, and they had 3 kids together. Everything was great, everyone gets along, except that their youngest, Sammy, was really irresponsible. And they knew that someday when they died, if Sammy got his 1/3 of the estate, he's going to go out, he's going to have fun, he's going to spend it, and there'd be nothing to show for it. And Steve and Stephanie, they'd worked for years, they'd carefully saved, they invested, they built a nest egg for their family, and they really didn't want that to happen. And so, one of the things that they could have done, that they didn't in this case, is they could have in their wills made a trust that describes how the gift for Sammy would be held, to try and control how he would have access to the money in years to come, so that somebody else, someone more responsible, maybe one of the other kids or a different relative, could look at what Sammy wanted to do and decide for each thing whether the money would be made available or not. And so in this case, they didn't. Sammy got everything and he did spend it all very quickly. So those are just 3 examples of things that can go wrong. So we can have things go wrong when we didn't make a will, but all of you done that. And things can go wrong when we make a will, but we don't go far enough. And so if you work with lawyers or notaries, I'm sure your plans are comprehensive, and I don't have a whole lot more to tell you. But it's just important to be careful and think about the things you haven't thought about. So if you didn't work with a lawyer or a notary, or if you feel like it wasn't comprehensive, maybe go back to them and just ask, like, have we dealt with these different things? And it's good to also just take the wills that you made in the past, and if it's been a year, 5 years, 10 years, pull it back out and make sure it still is what you want. And think about how things have changed in your life since you made the will. Things that you bought or things you don't have anymore, people in your life that have joined your family or people that have died, and make sure the will still is what you want it to be. So they don't expire, but life happens and your will might just be out of date. I could tell you lots more things about wills, but let's move on since you already have them. The other things to think about is that a will describes what happens to the things you own after you die. While you're alive, the will does nothing for you. It's just paper sitting on a bookshelf or wherever you've hidden it. So if you're alive and you get hurt, 2 things that do help you are powers of attorney and representation agreements. And are you familiar with those? Some nods? A little bit?
Power of attorney.
Okay, so the whole idea is both of those apply when you're alive, but at a time when you need or want help. A power of attorney lets you choose a person who will manage your legal and financial affairs. And then a representation agreement lets you pick a person who will make decisions about your medical care. And again, it's a time when you need or want help. So you might be, you got a car accident and you're unconscious, then this person could speak for you. Or if you're suffering from Alzheimer's and you don't understand what the doctors are suggesting, again, this person you trust can speak on your behalf.
But that's only for medical?
The representation agreement is just for medical.
Okay, so the power of attorney.
It's just
can it cover-
legal and finance.
Can it cover both?
They're two separate documents. You could have the same person in both roles,
I see.
but you would need both documents.
Okay, so that person can then do whatever she wants to do.
So on
While the
the
person is still alive.
power of attorney side of things,
Yes, she,
their role is basically as a business person.
the financial.
Yeah, so they can do not quite whatever they want to do. They need to do what they believe is in your best interests.
But now tell me, is there anyone that controls this? If you have a power of attorney over, I'm talking about a friend who's not going through this.
Yep.
Alzheimer's or dementia, or, forgetfulness. So that person that has the power of attorney, which I know she has because I've seen the paper, she can do pretty well everything. Is there no one looking over her shoulder? Like, I would like to see what she's doing. I like to advocate for my friend.
So generally speaking, there's not anyone looking over the attorney's shoulder. They can do what they believe is right. And by statute, their job is to help the adult that they're helping and not help themselves. So it's wrong for that attorney to go and take money.
But
There's nobody watching what's happening.
and especially this person who doesn't have any children. So she's totally in charge of my friend.
Yeah. And so if you have concerns, if you think that there's a possibility that the attorney is abusing the situation,
Yes.
then you can contact the public guardian and trustee. That's a part of the BC government that the courts and the PGT together have kind of a supervisory role,
Okay.
and they can intervene. So if they have a reason to believe that an attorney is doing the wrong things, then they can start a court process to demand that the attorney show records of what they've done and why.
Mhm.
But there's nobody watching day to day of what they're doing.
Okay. So the other question I have is now when it comes to the will, she's also the executor. So she can also, there's no one looking over her shoulder.
So on the will side of things, there's more oversight, but it's kind of hands off. The oversight comes from the courts.
Okay.
And so when someone dies and they have a will,
Mhm.
then their executor takes the will, and they go to the bank, or they go to land titles, and they say, this person died, I've got their will in my hand, I want to deal with their bank accounts. And the bank will look at them and say, I believe you that they died, but I don't know if this is the will we can use. We don't know if it's a real will or a forgery. We don't know if it's defective in some way that's not legally a will that we can use. And we don't know if there's a newer will. Maybe this is a perfectly fine will, but the person changed their plans and made a newer will and didn't tell that executor about it. So the bank says, I don't want to give you this person's money and have someone else show up tomorrow with a better will and have to give them the same money a second time. So they say, instead of this, go away, go to the court and get it granted probate. And so probate is the process where we take this paper, what we believe is the person's last will. We send it to court with a bunch of other paperwork explaining the circumstances. And we get back a court order saying, yes, really, this is the will we should follow. So now when you go to the bank isn't following you and this mysterious paper. They're following a court order saying that you are the executor and that this is the will they should use. So probate is a good thing of giving everyone the confidence that we're doing the right thing. We're following the right will and the right person is doing the job.
And you have to probate anyway, because it's over a certain amount of money.
So whether you do or not depends on a whole lot of things. It's not automatic. But if the deceased owns real estate in their own name and not with anybody else, or if they have more than usually about $20,000 or $25,000 in the bank, or if they have a vehicle worth more than about $25,000, then the agencies that control those assets will insist on probate. So it's not that when you die, your will has to go to probate, it's that when somebody dies, the person controlling your assets won't cooperate until they see this order from the court. And so if you arrange things in a different way, you might be able to avoid that process. So spouses typically own a lot of things jointly, and for spouses, we often don't need to deal with probate. When the last spouse dies, we usually do. Does that make sense?
Yeah, so the other thing is, so being the executor and my friend not having any family, I know I've seen the will, it goes to her family in Europe. So what fee will the executor be able to take? There's no one overlooking that as well.
So sorry, go back to the idea of the court oversight on this.
Yes.
Is that the executor is entitled to collect a fee either described in the will, a specific amount,
Oh,
or the trustee act says that executors can collect up to 5% of the estate's assets.
5% of the,
And up to is kind of vague, so the court has said really, most of the time it's more like 2% unless it's a lot of work. And so it would depend on the circumstances. But the way the court oversight comes back to this is that any beneficiary, and really anyone that has any interest in the estate of any kind, can apply to the court, and the court will demand that the executor provide an accounting of the estate's assets. And so that's a way for the court to look at the executor's receipts, all the money they've brought in, and how they've passed it out to everybody. And the court will either sign off saying that's okay, you've done the right things, or the court will order that things be done differently. So that's the oversight part on an estate, that the court is still involved. Often we skip that step if all of the beneficiaries agree in writing, they can sign off and say we're not going to do that. But if any of the beneficiaries has a concern, they can demand that process.
and in order for the beneficiaries to know exactly what's in the will, she will have to send a letter showing.
Part of the court process for probate,
Showing the
it
will.
involves sending a copy of the will.
Showing a copy of the will.
Yeah.
So it's pretty,
And then the will becomes a public record in the courts as well, anybody can see it if they want to.
okay.
Does the executor require a death certificate in order to access a will in the safety deposit box?
Oh, yeah.
If it's in a safe deposit box, it would depend on the bank, but generally yes. Unless they have the key and if their name's on the account, then nobody would be able to access that safety deposit box without either the grant of probate, which you can't get without the will, or else a court order saying that's the right thing to do, or the last option is that you convince the bank that the will is likely in there, and they get a locksmith to break it open and you get the will out.
So isn't that registered in the provincial government somewhere where they have documents of?
So there's a will registry with vital statistics down in Victoria. You don't send the will itself, it's just a notice of where to look for a will.
Okay.
And it's completely optional. So someone may file a will notice saying, my will is at, I don't know, RBC downtown here in Penticton. All it has is an address and the date that the will was made. So if I've moved my will, I don't necessarily have to update vital statistics. If I made a new will that replaces that one entirely, I may not update that either. So the wills notice is a starting point, but it definitely isn't conclusive evidence of whether someone had a will or not, or where to look for it.
So another thing is, can you just make a copy of your will and give it to each of your beneficiaries beforehand?
So the will is your secret.
Yeah.
You can share it with
I would
anybody
like
you
to.
want to.
Wouldn't want to.
The one reason that I sometimes discourage people from that is simply if you've given them a will and then you change your mind and you give them a smaller share, they may be more disappointed than just the surprise later.
Exactly,
And on a more legal side of things, is the original will that matters. So the paper that you signed is the one that needs to be used for dealing with your estate. And so a copy is helpful, it's evidence of what was once the plan. But if the original paper is missing, then we can use the copy, but we need to convince the court that that copy should still be used. So the issue is that one way to get rid of your will, if you don't like what it says anymore, one way to cancel your will is to just destroy it. Shred it, burn it, whatever you want. And if your will is missing, and someone has a copy, there's a question of, is it more likely that you destroyed that will to get rid of it, or is it more likely that you just lost it and we should still follow the copy? That's a question that a judge decides. So if you don't have the original, we can still deal with your estate, but it comes to convincing a judge which of those options is more likely, and it's a judge's decision of which plan it's going to be.
It gets really tricky when the executors are your children. Because you want your executor to know where the will is, right? Because otherwise, if he doesn't know where it is, then.
It's important that the executor knows where to find the will.
Yeah.
If the will can't be found, then we deal with your estate as if you had no will.
But if it's one of your children, as you were saying, all of a sudden, you have a discord and then it happens, it's gonna be, I would change it, right? I would put a codicil, right?
Yeah.
Yeah. How
And
many
so,
codicils can you add to a will?
so you can add as many codicils as you want.
Oh.
It's a separate document
Yes.
that leaves your will alone, but amends it by saying, effectively, scratch out section 3 and put this in its place.
Yes.
And you can make more and more and more, but it becomes harder to read as you add more of them on.
Okay.
So at
And
some point, it makes sense to make a fresh will because putting several codicils together is just unwieldy.
Another thing is a question, if you change your executor, do you have to notify him?
So the executor is appointed by your will at the moment you die.
Okay, so it doesn't
So
matter.
it's courteous, it's convenient if they know that they have this job coming. But if you change your mind, you don't even need to tell them because the final will, that's the one that matters, and they don't actually have that job until you stop living.
Okay, pretty clear, thank you.
Do the amendments have to be obviously have to be notarized, so you have to go back, you don't have to go necessarily back to the original notary, you can go to any notary with the will and have them put amendments on that will.
Yeah, so the amendments to the codicils, they need to be signed in the same way as a will does,
Okay,
which just means any two adults that are not part of your estate, so not your family, not receiving a gift, not the executors, any two adults need to witness you sign.
okay,
They need to be present in the room when you sign, you need to still be there when they sign. But aside from that formality, as long as the codicil is clear, anybody can make it. It does not need to be the original lawyer. And just one more thing on that is, if I had made your will, then generally instead of making a codicil, we would just edit the original file and print a fresh will, so that we don't have to have a second document to deal with. Just one clean new will.
and does the notary office keep a copy of your will?
Depends on every office. Lawyers in the past and notaries used to have vaults full of wills. And it has become a problem, especially for the governing bodies, the Law Society, that when lawyers retire or die, if they haven't dealt with their practice, then these vaults full of wills get sent to the Law Society. And they're complaining that they've got warehouses full of people's wills,
Yeah,
Yeah.
and families are complaining that their lawyer had died, they don't know where to find it. When lawyers move to a different firm, all those different things make it hard to find your paperwork. So as a profession, we're being encouraged to not store wills. So I have a safe, we keep some in there, but it's really special cases. Normally I give it to you to keep. We keep the files though.
okay,
So
so I
if-
do have a copy of my will, obviously, but I wasn't sure if the notary, this is from 20 years ago, right? So I don't know can't remember whether she kept a copy or not.
And yeah, no idea.
Okay,
It would be, we keep the files so we can print it again, but I don't make any guarantees. If we had
Okay,
a catastrophic hard drive failure, I can't guarantee that we still have your paperwork, but
okay,
if we do, we'd be happy to do whatever we need with it.
So you can also appoint a lawyer to handle your estate, right?
You can appoint anybody you want as your executor. There's professionals like lawyers, some accountants, the banks have trust companies attached to them.
Okay.
They all provide those services. Not all lawyers or not all accountants do that kind of thing. And typically, the professional fees tend to be towards the upper limit, the 4 or 5% that's allowed.
Yeah.
so I'm common law with my husband for 18 years. Is that any different than being married for any?
So common law spouses have all the same rights as any other spouse.
Okay,
The only real difference comes when spouses separate. The rules for when a
Okay.
common law spouse, when a common law relationship ends are different than when a marriage ends.
also,
With a common law relationship, you're deemed to have separated when either of you has the intention and carries that out. So you don't even have to actually move out, you just say, I'm fed up, this is it, we're done.
okay,
Where when you're married, you have to actually take steps and create a
Okay.
separation. So there's some nuance to it, but it's a little simpler to end a common law relationship from the estate side of things than a marriage.
okay,
So when one of the partners passes away, automatically it's treated as a husband,
Yeah.
registered.
Yeah.
spouse.
If
So
you're together when
property
you
will
die,
go over
then there's spouses in every way.
entirety to the other person.
Yeah.
Unless you make a a note on your own will that it will go to your children instead.
That's right.
And that was actually one of my questions too, because on my husband's side, there are some individuals that are less prudent with using money. So what we did was, so if something happens to me, a certain percentage or whatever, I don't even remember exactly, goes to my husband, but I wanted some items, and my financial advisor helped me with that, to go to my nieces and nephews, as opposed to everything going to my husband.
Yep.
Because I was told that if I die in a car accident and he dies the next day, so my stuff would have gone to him, typically.
Yep.
And if he died the next day, then his side of the family would have had all my assets. So I didn't want that. So what I did is I had, like I said, he gets the house and my pension or whatever, kind of pension, stuff like that. And then I think, I can't remember exactly, 20% went to each of my nieces and nephews or something like that.
Sure.
So that is not going to be an issue, right? If I had in my will those little.
Yeah, so there's lots of ways we can deal with that situation. That's one way where you give most things to your partner, but something gets carved off for the rest of your family right
Okay.
away. Other options would be that you and your husband could make your wills at the same time with a plan that describes how things would go to the survivor entirely, and then when the survivor dies, that's when everything's divided among your extended family.
Yeah.
The risk with that is that if one of you dies, the survivor gets everything. If they change their wills later, they have no obligation to give anything to the first family. So we can bolster that plan with an agreement between the two spouses saying that they won't change their will in the future in a way that leaves that plan
That's
behind.
okay.
So it all depends on your circumstance of whether it makes more sense to give something right away, which has the effect of depriving your partner of something, or if it's better to take this second plan, give everything to your spouse, and then trust them and count on them to follow through with giving everything to both families.
Now, does that include pensions? For example, the Canada pension? I think what I did was I left that for my spouse, but my private pension through my work, I believe I gave it to my nieces and nephews or whatever.
So investments like pensions,
Yes.
life insurance, RSPs, RIPs, TFSAs, where you have a beneficiary,
Okay,
generally speaking, those go to whoever you've named and the will doesn't affect it. So if in your pension you left a gift to anybody at all, your will is not going to change that gift.
okay. So, that answered that question. Okay, so my next thing is, because dementia runs in both our families, unfortunately, so as I said to my husband, it's going to be lots of fun later. Because, anyway, so I have my power of attorney, which is my niece, and I believe his sister is his. What if there is a difference of opinion of what to do with us, sort of thing, because each person might have a different idea.
Yeah.
What is a safeguard for that? I guess
There isn't really, it just comes down to you, while you're healthy, coordinating between your niece and the other choice for attorney,
Yes.
to make sure they have a plan of how they're gonna make those decisions.
Okay,
And it's on you to decide with them how to coordinate decision-making in a way that they don't just have a deadlock. Right? It's not really a vote, it's one's dealing with your assets, one's dealing with his assets,
yeah,
and making sure that all of your bills get paid once but not twice and they don't get missed. Making sure that if you need to move into care, that you both get together the best you can or whatever.
yeah,
So often, not always, but often we would encourage you to have the same attorney for both of you, so that one person's dealing with your family instead of one trying to deal with half of your things, the other dealing with half of your things. But it really just comes down to picking the right people that can do the job, and part of that is that they would need to coordinate some things.
and how would we pick a lawyer to do that? But that, you're saying to have the same lawyer, that would be our power of
Sorry, no, not the
attorney?
same lawyer, the same attorney, so same.
Same attorney, so our power of attorneys powers of attorney would be, that's what I would tell them to do, is that what you're saying? Not for me to make sure the same lawyer would be doing that, but.
Sorry, no, not lawyer at all.
No,
I'm saying that when you appoint your power of attorney, the person's job is they're your attorney, they're your helper,
Okay,
not necessarily a lawyer.
okay,
And if you and your husband both chose the same person as your first choice, then one person is dealing with your whole family's situations.
okay,
And that can work if you both agree on who that could be.
Yeah, that might well, just because.
Yeah. And if it doesn't make sense for you both to choose one, then you've got different people, and while you're healthy, it's important that those two people know how to get along and how to make decisions together.
Okay.
So it's on you and your husband to make sure that the people you've chosen can actually do the job you're asking them to do.
You still on the roll?
And medical power of attorney, what is the best way to have that all set up?
So that's that representation agreement. Okay.
Yes.
And the best in what way? What's your question?
Is that part of your will?
No, these are all three separate documents: a will, a power of attorney, and a representation agreement. The person you choose as your representative could be the same person you choose as your attorney. That could be the same person you choose as your executor, but they could be three different people.
Okay.
So someone that's good with your money would be great as your attorney, but they might not be a good choice for medical decisions. So maybe you want a different representative. So it depends on the people in your family.
And that would be a notary we would go through to have those documents done, right?
Yeah, a lawyer.
And it depends, of course, if you want to do the medical, one of us would like to do the financial rather than, would not do the financial, but he's good at medical, he may.
Well, my niece is an accountant, so I figured she's not gonna, and I trust her too with
If she's
the medical part.
Okay.
Because if he's got dementia, he's not gonna know what to do with me, right?
Anything after
Oh, go ahead.
Okay, so I'm talking about property now. I own a house and I don't want to sell it before I pass away because I want to live there as long as I can. Should I put my son on as a joint tenant? Because it's a large, it's over millions.
The short answer is no. The reason that people want to do that is to avoid probate fees
Yes,
and to make it easier to pass it on.
yes.
There's three disadvantages. The biggest one, well, let's start with the major one, is that for your home, while it's your principal residence and you're the only owner, it's entirely exempt from capital gains tax. So as it goes up in value, there's no tax on it.
Yes.
If you add somebody else as a joint owner, they own half of it, and it's not exempt from capital gains on that half.
So,
Depending on who you choose.
but if he's also a principal owner, he lives with me.
Oh, if he lives in it, then that can be different. The other two issues to think about are that as another owner, they have all of the same rights you have for controlling the property, so they can interfere with your choice of paint colors or when to return the roof or whatever else.
He wouldn't dare.
And the third one is that they are also an owner in the sense that if they get in trouble, so if they get, even innocently, if they're in an accident, they're being sued, half of your home becomes an asset for their creditors. So for principal residents, I usually discourage parents from doing that because we don't want to risk your home for their creditors. And the advantages usually aren't compelling enough to avoid it, but there's situations where it does make sense. So it'd be better if we sat down and talked about it in a little more detail.
But it could be, so when it comes to the capital gain, if he then is a partial owner, he's also then capital gain free? Is it half and half?
Yeah. And there's more rules. That principal residence exemption also includes specific relatives, so it's more complicated than I can get into right now.
Yeah.
But it can be a good option if you're comfortable with the other two parts, with having someone else controlling your property and the rest of your
Yes, so
creditors.
it's just having control,
Yeah.
trying to keep control.
If it was a vacation property, it's a much more obvious answer of sure, go ahead. When it's your home, there's the extra baggage of we don't want to deal with you losing your home for something.
Yeah, but the probate is very high though, if the house is then still in, oh no, it's,
So probate
there
fees,
is no probate if it's your principal residence.
there's still probate fees on it.
So when you pass away, the house will go into the probate.
And so then probate fees, it's a weird calculation, but you can think of it as 1.4%.
1.4,
So it's roughly $14,000 per $1 million.
14,000 per million?
Yeah.
I better write that down, 14,000. So the best thing would be to just sell it at, get your capital gain. Yeah. Yeah,
So
it's something,
It depends, from the money side of things, it depends on who's going to be the other owner, about how the capital gains are going to work out, and then we compare that to what the probate fees might be
Okay.
and the cost of setting it up.
Yeah, so how does that affect the taxes, the property taxes? So I'm over 65 or I'm getting, full benefits on
Yeah.
mine, and he is not. So,
The principal residence exemption on capital tax, or property tax, I think is that any owner qualifies for the senior discount, I think is enough.
is enough, okay.
It's off the top of my head, though, I have to double check.
Yeah, I just was interested in that. Okay. But if it's his principal residence as well, it's a lot easier.
It can be.
It can be easier. Okay, thank you.
What about capital gains tax? If that's what it's called, on RRSPs that have, or RIFs that have not been completely
So-
withdrawn.
RSPs and RIFs are their own special thing in the Income Tax Act. And the idea behind it is that you didn't pay tax on the income you earned in the year that you contributed. So in order to get some money back, the government treats it as if any money left in your RSP, or the RIF it becomes, any money left in it when you die is income in the year that you died. So if you had $300,000 still in your RIF when you die, it's as if you earned $300,000 in that year on top of whatever else you earned.
Oh,
Yeah,
so you have to leave enough money for the kids to pay for that.
Yeah, and
That
so
last tax.
Yeah.
return.
so your estate can have a significant tax bill, but that means that there was a significant amount of money in that account to begin with. So
Yeah, but,
It's
okay.
something just for families to be aware of.
or maybe pay tax on a little bit each year and put it into a TSFA.
There's lots of ways to deal with it. Often trying to get the money out of a RIF in particular as fast as you can. Within reason can be a good way to go. Generally, you want to do it with a financial planner and make sure that it's just making sense in the big picture.
Thank you. So, and again, going back to the dementia thing, so my husband and I both kind of deteriorate. For financial reasons, what is the best way to protect ourselves with our assets? At what stage, because I know when my mom's dementia progressed, and so we wanted to change her will because my dad was dying. We couldn't because she had dementia, and the person I spoke to said, you can't, because she doesn't really know the ins and outs, even though if I said to her, did you want all your money going to so-and-so, or whatever. So we couldn't change her will, we waited for too long to get the will changed. What is your recommendation to do if we both progress more or less at the same time, and we want to protect our assets? Is there any way to have someone overlook us even though we aren't passed away or we're not in a facility yet? What is the best thing to do for having someone like my niece look after, or my assets anyways? I know it's gonna be complicated.
It sounds like you're describing what a power of attorney is for. That
While
as
I'm
you,
still alive,
while
she
you're
can
alive, she
still-
can help you with your investments and making sure that things make sense. Your attorney cannot change your will. So if you lose the capacity to change your will, you're essentially stuck with the last
Okay.
version.
Okay.
But your attorney can help you with those other things.
And what about, like I said, if we have joint accounts, my husband and I guess, like you said, they're just gonna have to get along more or less.
Yeah.
Okay,
I think Kevin's telling us that we're out of time here.
okay. No, I think you answered everything for
That's
me.
very interesting, thank you very much.
You're welcome.
Very, very good.
Yeah.